A will or a beneficiary designation on a registered savings plan or insurance policy is actually pretty simple. At least everyone thinks it's pretty simple. All it does is tell your heirs who gets what from your estate. Now, I know the legal language can be a little complicated, but designating beneficiaries is a piece of cake, right? And everyone should have a beneficiary. All you have to do is fill in some blanks in a form or a draft, and there's some great advantages. And not only can this save thousands of dollars in probate fees and estate settlement costs, it can also dramatically speed up the distribution process. So you really believe that? Well, hold on a minute. What you don't know about beneficiary designations, and you've heard me say this before in the overview sessions that I've delivered on this topic, may end up costing your estate and your heirs a lot of money, headache, and disappointment. In actual fact, as I'm going to emphasize today, designating beneficiaries is neither simple nor straightforward. And if you don't take care to do it right, you could end up creating a variety of unintended legal, financial, and personal consequences. So first off, for yourselves, and again, repeat this to your clients, do not make assumptions. Instead, take the time to understand some of the common pitfalls surrounding beneficiary designations so that you can be sure that a decision about what to leave to whom doesn't trigger some type of an estate planning disaster and perhaps some problems for you as an advisor who recommended the setup. Now, I recognize that most beneficiary designations are made with good intentions, a desire to make an estate as simple as possible, an effort to reduce probate fees owing upon death or estate settlement costs, or perhaps it's a wish to provide a different type of distribution to one's children or heirs. But some of the worst roads that our heirs end up traveling on are paved with a topping of good intentions. As in all my sessions, I remind all the attendees that according to our legal and compliance department, this is the most important slide in the entire presentation, this disclaimer slide. Now, the document does reflect the views of Empire Life as of the date published. I say this because if you're watching this presentation a month or 2 months from now, there may be another case that comes up from the courts or a pundit or a change in the legislation that may impact some of the things that are being shared today. And the information, of course, that I'm giving you today is for general information purposes only. It's not designed to provide you with formal legal, tax, financial, or professional advice. Now, the intention again of this session, even though I talk about some of the best intentions of advisors and clients is to minimize or avoid probate and estate settlement costs, is not to review probate planning in the various provinces and how that works. It really is focused on unintended and undesired results of planning that really doesn't consider the big picture and the rights, responsibilities, and limitations of various parties, including testator, trustee, and beneficiary, and what a judge may end up deciding on the balance of the evidence. I will share with you some of the unintended consequences of what I call short-sighted estate planning when it comes to avoiding probate or naming beneficiaries or setting up a trust that can lead to some of these unintended blowups. And I will take you through a number of case studies, including a number of cases from the courts, highlighting the strategies that they used and the pitfalls that were created, and hopefully cover off some lessons learned that you can use in guiding clients through the planning and review processes, which can reduce the financial and emotional fallout for your clients. So we'll go through the perils and pitfalls of naming beneficiaries, again, probate avoidance, estate equalization issues, unintended consequences. I will go through a fair number of case study examples, and today's session will really do a deep dive on investments. So all the decisions that you'll hear about, all the cases I will actually bring up will be very much investment focused. I do have a separate parallel presentation on a deep dive on insurance. And if you go back into the library of TRIIPSS webinars that we have delivered in the past, you'll find an overview session that has a nice healthy mix of insurance and investments. Again, for the benefit of attendees, if you're interested in a copy of this presentation, please reach out to your account executive and we'll be glad to send you out a handout version of the slide deck. Now, certain investment proceeds and named beneficiaries have a nice combination in the fact that you can name a beneficiary and those proceeds can generally pass outside the estate. We're talking here about registered retirement plans, whether those are registered retirement savings plans or rich retirement income funds, pension monies, segregated funds, insurance company GICs, and of course, insurance company tax-free savings accounts. And when properly set up, the idea is that not only will these proceeds pass outside of the estate, they're not included then in the value of the deceased estate for purposes of making all those calculations, and they're generally not subject to the claims of a will validity. And beneficiaries, hopefully, are protected. That is, of course, until someone starts arguing or debating or screaming about the fact that they didn't get a fair share. But there are all kinds of exceptions, and they include dependent relief, joint ownership situations, scenarios where the payer is not the life insured, or where advisor failed in their duty to advise. And what can happen is that whoever you thought was going to get the money doesn't end up getting the money, or not all of the money. If we're looking at situations like dependent support claims, I'm going to use as an example the Succession Law Reform Act of Ontario Part 4, but every jurisdiction has rules and regulations governing dependent support claims. And typically, the definition of a dependent includes a spouse, a common law partner, a child, particularly a minor child, even a sibling, a brother or a sister. Whether the deceased was under an obligation to support these people, and you would recognize that, yeah, you may have an obligation to support a spouse or a common law partner or a minor child, but why would you why would you have to provide for a sibling? How could a sibling be dependent? In fact, how could your 35-year-old son or daughter claim that they are dependent? Well, again, the rule and definitions under dependent say if you are under an obligation to do it, or you simply did it as a matter of habit. You provided support for an extended period of time, and they will make a case that they relied on that money, notwithstanding the fact that you may have provided for 3 children. If you had 3 children, to divide your estate equally, the one may come up and said, you know what, equal doesn't work for me. I need more money, and they may be able to build a case to in fact get a disproportionate share of the estate because they're filing not only as a son or a daughter, they're filing as a dependent. And then designated proceeds may be used to satisfy those claims, whether we're talking about life insurance proceeds, in fact, whether we're talking about life insurance based proceeds, so segregated funds or insurance company GICs, they could apply to other things as well, like registered retirement savings plans, registered retirement income funds, and the like. And particularly if there are insufficient assets elsewhere. Sometimes if there are not assets elsewhere, these assets can be protected, but maybe not. So what could that include? Again, I talked about life insurance and the life of the deceased. You may say this is investment focused. Why worry about that? Well, some of these life insurance policies are designed as an asset class that can accumulate significant amounts of cash value. So there is that investment component. Group life insurance on the deceased, of course, that extends, of course, to pension plans, whether we're talking about defined benefit pension plans, defined contribution plans, individual pension plans, registered retirement funds owned personally on an individual basis, insurance company GICs, segregated funds, and of course, annuities. If we go on with the list of exceptions, we can extend those things to certain creditor claims, as well as claims made by the Canada Revenue Agency or the CRA. Exceptions also include the fact that if you are deemed by the IRS, the Internal Revenue Service in the United States, of being a U.S. person, so you are a U.S. citizen, you are a green card holder, you're a deemed resident or a domiciliary, then when they're doing the calculation of estate taxes, and the United States has estate taxes at both a federal level and many states have state estate taxes, typically the value of life insurance owned by you, if you had an incidental ownership in that policy, it was on your life and you were the owner of a third-party policy, so the cash values of those contracts, but the sums insured could be included in determining the value of your gross estate. And then estate tax is applied at that level of your gross estate. They don't actually tax the life insurance, but it's used to make the gross estate bigger so that on a graduated rate basis, they can tax the balance of your estate at a higher level. There are workarounds that I can deal with, not today, of course, but you've got to think about that when you're setting up beneficiaries and ownership structures for life insurance policies where you're dealing with U.S. persons. And then, of course, there are third-party policies where the cash surrender value, and maybe even the sum insured, maybe could be to be brought in some way, shape, or form. Again, if a deceased owed money to the Canada Revenue Agency or the CRA, then that organization may pursue payment from a beneficiary on a segregated fund policy, a reg retirement savings plan, a reg retirement income fund, to name a few. The naming of a beneficiary, of course, has no bearing on the inclusion of the value of a life insurance policy proceeds on their gross estate. So in Canada, you're thinking, well, if I name a beneficiary, if I name anybody's beneficiary when I pass away, but if I name somebody in the protected class, that's going to be protected from anyone's going after my estate or taxes on my estate. Well, not necessarily, again, if you're dealing with Americans. Also consider what happens when a policyholder dies owning a life insurance policy on another person. So this is a Canadian example. You've got an interest in a policy on the life of another person. Again, except for Section 148 rollovers, whether that rollover is done on a tax-deferred basis to a spouse or a child directly, unless that happens, there's going to be a deemed disposition of the policy for income tax purposes. And that includes a transfer to a child by will instead of a direct successor owner designation. So again, lawyers sometimes get involved and said, well, let's include a transfer to a policy. We'll take care of all that in the will. Then it won't qualify for the Section 148 rollover, and there will be a deemed disposition. And again, it doesn't matter what beneficiary designation you had set up. It doesn't matter at all. It then hones in on the ownership structure of those policies. And with all of that, you get some unintended consequences, a number of unintended consequences. In most cases, joint ownership and beneficiary designations made directly within a reg retirement savings plan or a reg retirement income fund will override designations made in your will. But again, in case of conflicting beneficiary designations made directly within those registered accounts and wills, generally speaking, the latest valid designation is upheld. So if there's a valid designation made in a will after the designation made in a reg retirement income fund or a reg retirement savings plan, regardless of whether this came from an insurance company, then the latest valid designation would be upheld. There may be problems with asset transfers. Many people assume that beneficiary designations automatically transfer when assets such as reg retirement savings plans move from from one financial institution to another. That isn't always the case. In a worst case scenario, an asset that's intended to be passed on to a particular heir ends up passing through the estate instead because a beneficiary designation was never updated or revised after that transfer. And of course, the same thing can occur from a legal perspective when you're converting something, and you'll think of it as a conversion, when you're moving something from a rich retirement savings plan to a rich retirement income fund, even within the same organization. Now, Empire Life has an exception on that. We would maintain that beneficiary designations, but that necessarily isn't the rule of law. So if you don't make that beneficiary change or check on it, then the beneficiary designation may be lost when you move from a rich retirement savings plan to a rich retirement income fund, even if all the underlying investments are the same. A formal split with a spouse does not automatically revoke a prior beneficiary designation. That's a general statement. Each province handles that differently. But in most cases, a new beneficiary designation must be made before a previous one is revoked. So this is not like reading a will. Quebec is an exception where divorce nullifies a beneficiary designation in favor of the ex-spouse. Let's look at the income tax burden here on what happens when policies contracts that could attract taxes are passed outside the estate. Again, in most jurisdictions, debts and taxes owed by the deceased estate must be paid before assets can be distributed. And those costs are usually paid from the estate itself. If the executor, the estate administrator, does this prematurely, they can be held liable for the difference. And of course, that can result in a grossly unfair allocation of an estate's tax burden. What's the example? And I'll go into this a little bit later on, but let's say you designate your son as the sole beneficiary of your rich retirement savings plan while leaving the rest of your estate to your daughter. Your daughter could actually end up paying the tax on your son's inheritance. Now, if that isn't room for conflict, there are other things as well. And it's often the most devastating consequence of an incorrect beneficiary designation or a beneficiary designation that really hasn't been thought through. It's the legacy of conflict that it leaves for the family. Family members arguing over their respective shares of a deceased's assets, children issuing legal challenges to a parent's will, and then bickering and squabbling to get their fair share because of contradictory designations or designations that don't make sense in their eyes. And all of it is not only possible, it's probable. In fact, it's happened. It continues to happen if you fail to make beneficiary designations clear. So where does that bring us now? Let's look at registered retirement plans and the naming of beneficiaries. Let's say that you're single, you're divorced, or widowed. So there is no spouse in the picture. You have saved up some money for retirement. Perhaps you're already retired and you're taking out an income from your registered plan. You may not get to spend all of your savings during your lifetime. Where does the balance go? Well, one of the strategies that you can use for a registered retirement savings plan or a registered retirement income fund is to name a beneficiary or several beneficiaries. The balance of the plan goes directly to that person or to those people after you pass away. It passes outside of your estate. That means it doesn't form part of the assets in your will, or it doesn't have to go through probate. All of it goes to the person or people you choose to receive that money, or to a charitable cause, if that's where you put the money, although that won't necessarily cause a tax problem. That's right. The beneficiary normally doesn't even have to pay the income tax on all that tax-deferred money. That's the bottom line. Charity, daughter, son, niece, nephew, next door neighbor. But income tax still has to be paid. That bill goes to the estate, and your executor or estate administrator must pay the income tax that is owed on that registered retirement plan. So cash, investments, or some other asset in your estate will be used to pay the income tax bill. Okay so far? But what about the beneficiary of the estate? They, in fact, shoulder the income tax liability, while the beneficiary of the registered retirement plan gets all of that money, every dime of it. There is no holdback. Those other beneficiaries may not think that's fair. You may not have intended that to happen. The person who got the registered retirement plan may also be a beneficiary under the will. That means they stand to get a lot more of the estate. Was that the intention? Was that the plan? And that scenario is fairly common. Unhappy beneficiaries, who may be brothers and sisters of the beneficiary named under the registered retirement plan, may well dispute that outcome, and they may even go to court to get satisfaction. So the Morrison versus Morrison case, or Reed Morrison case, that was settled in Alberta in December 2015, that's an important date that I've written about before, settled in December of 2015, dealt with just that kind of scenario. So what happened in this case? Well, John Morrison drew up a will dividing his estate amongst his 4 adult children, and each of his grandchildren were to receive a small, precise amount of money. One son, Douglas, was subsequently named the sole beneficiary of John's registered retirement income fund. He cared for his dad. He was one of the executors as well. So it appeared at the outset that maybe that John, the father, wanted Douglas to maybe get a little bit more. But the problem is that when John died, Douglas found out he was to receive the proceeds. He didn't know this ahead of time. He found out he was to receive the proceeds of his dad's registered retirement plan and was entitled to 1/4 of the estate. The estate was responsible for the income tax on the registered retirement income fund, and that reduced each child's balance of the estate. Worse was that there wasn't enough money to provide for that specific amount that was gifted to each grandchild. So the siblings went to court, and they argued that the registered retirement income fund should be part of the estate and it should all be divided up. But the judge ruled that on the balance of the probabilities, John, the father, had intended to gift the registered retirement plan to his son Douglas. And the court ruled that Douglas did not have to share the proceeds from the registered retirement plan because it was his outright. However, the judge did order John to pay the income tax on those funds, and that was an unusual decision that relied on a piece of Alberta legislation. The judge admitted that his approach was extraordinary in claiming that Douglas was unjustly enriched and must reimburse the estate for the tax it paid on his behalf. So the judge inferred that Dad, the John, either didn't know or he was mistaken about how the income tax liability would be borne. And that's what happens with inadequate documentation. It happens when you don't follow the recommendation that I've made so many times over the years, that you need to periodically stress test your solutions, your plans, your strategies to make sure they continue to do the job they're designed to do when you first set them up. So what happens is the court kind of pulls up a crystal ball and says, well, here's what I think that John was thinking. On the balance of probabilities, here's what I was thinking. And the judge ruled that John probably didn't know how the income tax was going to get paid, and that was not the intention. And he felt it reasonable then that Douglas, who received the Reg Retirement Income Fund as an extra gift, should pay the tax on that. But again, something to keep in mind here for a little bit later on is that the judge said reimburse the estate. So what happens when a court decides that a beneficiary designation is actually held in trust? So a different decision that happened in the Morrison case. Well, let's consider Kamusky versus Kamusky, which has caused quite a stir in Ontario, decided this year. It was decided, in fact, in March. Henry Kamusky passed away at the age of 94 in 2016. He named his son Gary as a joint owner of 3 bank accounts. He also named Gary as the sole beneficiary of Henry's, his dad's, Reg Retirement Savings Plan. In fact, it was a Reg Retirement Income Fund. It's important to note that when Henry named one of his sons, Gary, and he had twin sons, so he named Gary as joint owner of his bank accounts with rights of survivorship, only Henry contributed to those funds. Only Henry, while he was alive, used those funds, and only Henry used and declared any of the income on those funds. But there was no other documentation or rationale or intent expressed that anyone could come up with after the fact. And Henry had owned jointly owned accounts. He understood how jointly owned accounts worked. He had owned jointly owned accounts with his wife Mary until she passed away, and Gary had taken care of his mom until she passed away. And then the accounts passed to Henry by rights of survivorship, and Henry thought, I'm going to do the same thing for Gary, who's doing so much to help me out, and he helped out mom. Gary had moved in with his parents in 2013 for financial reasons, and of course to help for his mother until she died a year later. Henry drew up a new will 2 days after Mary's death, accompanied by both of his sons. And there was no mention of the bank accounts. There was no mention of the Reg Retirement Income Fund. So no one disputed that Henry and Mary were financially generous with the boys on a balanced basis. Mary and Gary, in fact, so the mother and Gary, the Gary who was the joint owner and the beneficiary of the Reg Retirement Income Fund, had invested and lost significant monies in Gary's twin brother, in Randy's business, which went bankrupt in 2013. It was one of the reasons why Gary, in fact, had to move into his parents' house for financial reasons. See, between the two of them, Mary had invested $200,000. Gary had invested $135,000. So combined, $335,000 in Randy's business. Randy's business went belly up. Justice Lococo of the Ontario Superior Court ruled that the proceeds of the bank accounts and the RIF belonged to Henry's estate, notwithstanding the fact that it had been set up as a joint ownership with the rights of survivorship on the bank account side, and that the RIF had a named beneficiary. What Justice Lococo did is that he applied the principle established under the Supreme Court of Canada decision in Pecor versus Pecor. A transfer of property for no consideration to an adult child is presumed to be a trust in favor of the estate. And the judge did not feel that Gary was the beneficial owner of the 3 bank accounts totaling $285,000, or the Reg Retirement Income Fund valued at a much more nominal amount, $41,000. It was up to Gary now to prove that the transfers of property were intended as gifts from Dad, but he couldn't do that. He couldn't do it, certainly to the satisfaction of the court. So Gary had to share everything with his twin brother, Randy. So in his reasoning, and it's important to understand the reasoning, how this works, because this can have a trickle effect here, a domino effect. What Judge Lococo said is that, upon review of the Reg Retirement Income Fund beneficiary designation, being about half a page in length, this was the entire review dealing with that particular issue, that document clearly provides TD, and it was TD that actually held the RIF, with the authority to pay out the funds to the designated beneficiary upon the RIF owner's death, unless TD is satisfied the designation has been validly revoked by later designation or a will. And TD Didn't have that on record. TD said, no, we're supposed to pay this to Gary. That's we should do that. But there's a big but that came afterwards. And what the Justice Lococo said was that I do not consider the contents of the beneficiary designation to be detailed enough to constitute reliable evidence of Henry's intention relating to beneficial ownership of the RIF funds. And that was fairly damaging when he actually put that in there. So Justice Lococo said it's being held in the presumption of a resulting trust, and a resulting trust for the benefit of the estate. And he relied on a couple of cases for that, a number of cases. But the big case he relied on was, of course, Pecor. Went to the Supreme Court of Canada back in 2007. We also consider the Sodden estate case, Ontario Court of Appeals case, 2014. But in the Pecor case, the ruling was that when a parent transfers property to his or her child for no consideration, the law presumes that the recipient child or children hold that property on resulting trust for the parent, and the onus is on the children to rebut that presumption. So in that situation, again, using Pecor, it was up to Gary, one of the twin brothers and the joint owner of his dad Henry's bank accounts, to rebut the property, put the property receipt and rebut the presumption of resulting trust. He held legal title to property. No one's going to argue that. It passed him by right of survivorship on Henry's death. But did he also become the beneficial owner of the transfer? And the judge said, no, not the case. Not the case. Now, Pecor did not address whether the presumption of resulting trust should apply to a beneficiary designation made by a parent in favor of an adult child. And I think that's an important point to keep in mind. In the second case you see on the screen, in the Sodden estate versus Sodden, it established that the onus is discharged by the legal owner, rebutting the presumption of resulting trust on a balance of probabilities with respect to the transfer's actual intentions at the time they made the gift. At the time of the gift, especially when no money changes hands. What does that tell us? It tells us that we have to have documentation in addition to a beneficiary designation. So let's talk about some of the implications of the Kamusky versus Kamusky situation. What guidance can you go to for documentation that supports the fact that a beneficiary should receive the proceeds outright and not be presumed to holding in trust? Because there's doubt been cast now on how beneficiary designations on a registered plan, maybe even a life insurance policy, or that didn't even come into play here, would be viewed by a future court. That's a scary thing that's happened here. It could impact estate plans that are in place. It could impact probate planning. So document intentions here. Naming a beneficiary on a registered fund may bypass probate. If a registered fund is found to be held on behalf of the estate anyway, then the estate becomes the beneficiary and probate fees may apply on a registered fund. So now you appoint a beneficiary because you want that person to get it. But if it's dragged back in and said you're holding it as a presumptive trust, a further hit could be the fact that it could be included for probate fees as well. Now, we don't know if this case is going to be appealed or not. We don't even know if the precedent has been established. Will that actually be tested by a higher court? This has gone, it did not get appealed at this point in time. And so some courts may look at it, some courts may actually ignore it. The Supreme Court of Canada, though, wrote about the nature of the evidence that must be provided to the court to rebut any presumption of resulting trust. And there's a clue in here for us as financial advisors. A court cannot restrict its considerations to evidence of the donor's intention at the time of the gift. So what was your intention at the time you made the gift? What was it then? The court must also consider the donor's actions after the transfer to determine their intent. And here is where advisors have a role to play. A court may also look to the documentation relating to the property transfer during the donor's lifetime or resulting from their death. Who controlled the use of that property after the transfer? How were taxes treated on monies that were sitting in those accounts or those assets? So you need to document the conversations. You need to document the deliberations and the decisions leading up to a declaration of a beneficiary, and when reviewing plans and strategies and solutions as part of what I have always recommended as part of a regular stress testing exercise to assess their ongoing relevance. Now, is this needed for all cases? Well, maybe not, but it's especially important when the distribution of an estate is not considered equal or fair, and there may be a challenge to the beneficiary designation on the death of policyholder. And although this is an Ontario case right now, there have been similar court decisions in Manitoba, Alberta, and British Columbia. So document, not just write down a beneficiary designation, but document in your files, document in your reviews, the date the conversations held, and what the client said in terms of those beneficiary designations. What was the rationale? Are they supposed to share those assets? Are they supposed to get those gifts outright? Don't assume that will actually be the case. Now, an RRSP beneficiary designation appears to be a testamentary disposition. This is one of the reasons why a person acting on a power of attorney or protection mandate can't name someone like that. It's considered to be a testamentary disposition. Certainly in Ontario and in other provinces, as a result of Ontario's Succession Law Reform Act, to which I referred earlier, and also according to the Ontario Court of Appeal case in Amherst Crane Rentals versus Perrin. So will this case be appealed? Again, if a precedent is established, will it be attested by a higher court? So expect to hear a lot more on this, and expect to hear some pushback perhaps by bar associations, some pushbacks by the Conference of Advanced Life Underwriting to say, look, if you're going to hold an asset, a presumption of trust, please do not let it apply to an asset where there's named beneficiary. We'll see how far that gets, but expect that this will not be set aside and will not just lay there as a decision that will cause ongoing angst without any type of challenge. So what are some lessons and considerations? Well, what we can see is that there is an issue with naming an adult independent child as a beneficiary of a registered retirement plan, particularly if there are other beneficiaries of the estate. Now, you may want to avoid probate fees and estate settlement costs. I understand that. You may want to make the transition as seamless and efficiently as possible. You may want to leave someone something extra. But one issue is that the person receiving that money pays no tax. The estate pays the tax. That means the beneficiaries in the will shoulder the tax bill. And is that the intention? And again, in the Morrison case, settled in Alberta, again, late in December 2015, Justice Grazer found that the deceased father probably did not intend for the estate to pay the Income Tax Act. That John was either mistaken or confused or unaware of the income tax consequences of beneficiary designations. And you've heard me talk about this before in other studies. You heard me talk about this when I talk about value added to clients. That study after study showing that one of the biggest voids that exist in conversations between advisors and clients is the paltry amount of time that's actually spent making sure that clients understand the income tax implications of their investments and their decisions. So what happens when the named beneficiary of a retirement savings plan under the last will is different from the named beneficiary under a segregated fund that is a registered retirement savings plan? Who gets the proceeds? So let's consider the case of Frederick Littlechild and Louise Orpin. And this ended up going to court as well. They had been together for 22 years. They were married 8 years before Fred died. There was a trial separation for over a year prior to Fred's death, but Fred and Louise still kept in almost daily contact. Fred had 2 adult sons from a previous relationship. Fred ended up committing suicide, and Louise had been named executor of Fred's will. Now, on March 20th in 2009, Fred transferred his registered retirement savings plan from TD Waterhouse to London Life and to the London Life Insurance Company, and he designated Louise as the beneficiary of a registered retirement savings plan, which of course was in dispute in the court application. On March 14th, 2011, so just about 2 years later, the deceased Fred executed a new will by which he left his estate now to his 2 adult sons, and they were the respondents. That's March 14th. But on March 15th, the following day, the deceased signed a change of beneficiary designation with London Life, where he deleted the applicant and he designated the beneficiary designation, and he designated his sons as the beneficiaries of the London Life product. And on March 25th, he executed his last and final will, leaving his estate to Louise and designating her as the beneficiary of the registered retirement savings plan. Now, Fred did not concurrently or thereafter contact London Life to once again change the beneficiary designation for the London Life product, and hence the battle was on. So, who did Fred intend to be the beneficiary of the Rich Retirement Savings Plan held with the insurance company with all those changes made and a number of them made in very, very short order? So, here are the arguments. Louise said that all the monies that I may have at the date of my death in any registered retirement savings plan includes the life insurance policy, paragraph 3 of the will. And that wording was identical to the 2005 will naming Louise the beneficiary of the registered retirement savings plan at TD Waterhouse. The life insurance policy was held in the form of a registered retirement savings plan. And the wording, she said, was sufficient to describe the insurance and constitute a declaration in favor of Louise. So what is she referring to? The wording was sufficient. Well, the declaration, of course, is defined in the Insurance Act. And in Section 171.1 of the Act, it says, subsection 171.1 of the Act, it says that a declaration means an instrument signed by the insured with respect to an endorsement is made on the policy. It identifies the contract, or it describes the insurance or insurance fund or part thereof. And it can be a document where they designate somebody, or they alter or revoke a designation in favor of somebody else. And when we're talking about an instrument, that includes a will. So it doesn't just include a beneficiary designation on a policy or a change form on a policy, it includes a will as well. What the boy said, the little child's son said, is that a segregated fund is like an annuity, and as such, it's a life insurance policy. So a decision on adequate revocation of a beneficiary designation should be based on the Insurance Act, not on the Succession Law Reform Act. And a declaration in the will for purposes of revocation did not meet the Insurance Act requirements. And London Life was not notified of the most recent beneficiary change. Unlike the earlier one, this one, Fred was inconsistent. On earlier changes, he told the insurance company. On this latest change, the insurance company was not told. So the judge looked at this whole situation, and he concluded that the RRSP, the Registered Retirement Savings Plan, was deemed by the court to be an insurance policy based on the life of the insured, and as a result of the Insurance Act, not the Succession Law Reform Act applied, the proceeds ended up being paid to Louise. So let's look at beneficiaries and courts and registered assets. Well, on the subject of registered assets, we'll consider the case here of JR Succession versus the bank. This is an actual Quebec case here, settled in 2016, and it showed up in 2017. In this situation, Ms. JB has a registered retirement savings plan in an amount of more than $30,000 at CIBC. In June of 2013, a judgment of divorce is rendered again between her and Mr. JR, who's named, of course, in the suit, the filing. The judgment includes that Miss JB shall transfer to Mr. JR $30,000 in RSP within 45 days after the judgment is rendered on a tax-deferred basis by using Form T-2020. So this RSP then that she owned as part of the divorce settlement was to be transferred to now to him, to Mr. JR. So in July, again, the judgment of divorce that was rendered in June, and in July, she signs the Form T-220, sends it off to JR, but he doesn't sign the form. In fact, he dies in May of 2014. This sat on his desk in his office, or he lost it or something. He never signed the form. So somewhere between July 2013 and 2014, he did not sign it. And then on August 4th of 2014, the liquidator of the estate signs the form. They're settling up the estate. They say, oh, geez, the form was never signed. They sign the form. But CIBC refuses to proceed to the transfer because he died before the transfer was actually effective. They said, no, we're not paying it. We're not paying it to him. We're not doing that. So what was the position of the Canada Revenue Agency? Well, they looked at paragraph 146, 16B, and said that no, it does not apply to a transfer of an amount from an individual's registered retirement savings plan to his or ex-spouse if one of the individuals dies before the transfer is made. That was their position. The court looked at it differently. The court said that the death of the beneficiary of the transfer does not constitute an obstacle to transfer which had been ordered by a previous judgment. The court said that from the moment that the estate liquidator manifests approval of the transfer, the CIBC had to proceed with that transfer. And that judgment of divorce, which ratified the agreement on accessory measures, constituted an express decision of the parties on dividing on the family patrimony. The dividing became enforceable by the divorce, subject to the delay of the payment of 45 days. And from the moment the judgment took effect, the transfer of the amount in Ms. B's retirement savings plan, that $30,000, took effect in favor of her ex-husband. And the transfer became subject to an administrative formality, the idea of signing those forms, which death could not impede. So let's look at the tainting of the trusts. And this brings me back to the Morrison case. That case, again, is not unusual, where someone gets a retirement asset after the fact, and they said, well, who's supposed to pay the tax bill? How do we do this? And beneficiaries of an estate who find themselves in a similar situation can come to an agreement that the beneficiary of the retirement plan pay the portion of the taxes assessed by the estate. But they couldn't come to an agreement in the Morrison case. They may want to go a step further and obtain a court order that properly characterizes the payment. But if they don't, and that payment is made as a reimbursement of the estate, it could be considered a contribution to the estate. If it does that, it would taint a graduated rate estate. The new rules on graduated rate estates took effect in January of 2016. The Morrison case was settled in the middle of December 2015, 2 weeks earlier. If the decision had been made a couple of weeks later, if the graduated rate estate that holding had spilled over into 2016, there would have been a problem here. Let's go through that. Let's go through that with a case here that I actually have written an article on that you can actually access on the Empire website. So let's consider the significance of that decision made on the Morrison case in December of 2015. Let's meet Lorraine here, widowed on February 1st, 2016. As the estate administrator, she can choose the estate's first year end. It can be a non-calendar year end. She can elect to have graduated rate of treatment on her first tax return and maintain that status for 36 months so that the estate can be treated as a testamentary trust and be taxed at graduated levels instead of the maximum level for 36 months. And of course, the estate would have an additional year end on December 31st, in this situation, 2019. That second filing would be at the top tax rate, and then the estate's year end now remains December 31st. That's the way it works for graduated estates right across the country. Those rules, of course, on graduated estates took effect on January 1st, 2016, 2 weeks after the Morrison decision in Alberta. 2 weeks. Had that decision been made in January of the following year, had it been a situation where Morrison Sr. had died a year or two later, and we were in this situation where that 36 months hadn't passed yet, we'd be in real trouble by having the son, Douglas, reimburse the estate because he's tainted the trust. He's tainted the trust. Only the deceased can contribute to a trust or to an estate in order for that estate to be treated as a graduated rate estate. It would taint the trust afterwards. And besides all of that, why would you have courts guessing on what you were thinking here, on who's supposed to get the money? You can clarify what you want to have happen. Many estate intentions aren't clear, or they're not consistent with documentations like wills. They just aren't. So one option perhaps is to write a declaration of intention, which spells out who is to pay the income tax on the entire value of the retirement plan that is triggered on person's death. Another option is to name the beneficiary of the plan in the will and specify that the amount the person receives is net of income tax on that money. A third option is to buy life insurance, where the proceeds can be payable to the estate and used to pay off the income tax bill. Alternatively, it can be paid out to other beneficiaries of the will to equalize their share of the estate after the income tax is paid on the retirement plan. In any of those situations, make your intentions clear by discussing your estate planning with all of your children present. At least have it documented with your advisors, and stress test those plans and documents periodically to make sure they continue to do the things you want them to do. If tax has to be paid by the beneficiary, then make sure that they pay that tax directly to the Canada Revenue Agency. That's documented. Again, if they don't reimburse the estate, but they pay it to the executor, there's no guarantee that money will actually end up with the Canada Revenue Agency. So if you're going to get it for tag, and you could get nailed if the Canada Revenue Agency said there wasn't enough money in the estate to pay for it, let's make sure you've got adequate documentation and you follow a preferred course of action to make that happen. Now, the estate as beneficiary could be a sensible option. If you desire an equal distribution among your beneficiaries, make them all have it all payable to the state, or have them all named as beneficiaries outside the estate. If you have a beneficiary that must meet conditions or contingencies prior to receiving plan assets, you can name them an estate or set up a trust to take care of that. If the plan assets to be held in trust for beneficiary, for the reasons I stated number 2, or for some other reason, don't maybe get the estate involved. And again, by setting up something like a life insurance trust, if you're dealing with an insurance-based investment, either as a separate trust document or separate clauses in the will, then probate may still be avoided. And if specific bequests could become problematic, then you may want to put the estate as the beneficiary. Yes, there may be some probate fees that be payable, but you won't chew up massive amounts of money and time and really rip families apart because of the way you set up those specific bequests. I want to spend a little bit more time on when specific bequests could become a problem, like multiple beneficiaries or contingents. When you die with a registered plan, a tax bill is triggered as a result of it, and your plan beneficiary will receive those assets. We know that, and there's no withholding tax. Who's going to pay it? They're covered by the remaining assets of the estate, and if there are enough assets. And if there are not enough assets, then of course, Canada Revenue Agency has the opportunity to go after the beneficiaries directly. It's a good idea then to review your beneficiary designations annually and be aware that your beneficiary designations under registered plans, under tax-free savings accounts, will not be revoked or changed automatically if your family status changes. Not even in Quebec unless there's a formal divorce. Again, if you want to change your destination of beneficiary in the event of a relationship status change, complete a new form. So let's consider again what happens when a beneficiary designation and a will are different, and this happens all too often. In this case, McConomy Wood versus McConomy, a mother designated her daughter as the sole beneficiary of her rich retirement income fund, and the subsequent will named the daughter as the estate trustee, and the estate to be divided equally among 3 children. So we've got a conflict, or don't we? The RIF proceeds, not an insignificant amount of money, $392,000. Was the registered retirement income fund subject to resulting trust or other legal claim? And what Justice Harold determined is that there was lots of evidence indicating that the mother intended for all 3 children to benefit equally from the proceeds. So we held that the funds in the registered retirement income fund were held in trust for all children equally. Again, was that actually mother's intention? Justice Harold determined that there was lots of evidence supporting that. But a planning point for advisors is to have detailed documentation explaining the rationale for a beneficiary designation and document it then and document it whenever it is periodically stress tested to ensure that the plans, the structures, and the solutions continue to do the job intended. That's the evidence that becomes so very, very important. Also keep in mind that a designation or revocation made in a will is effective from the date of the will, not the date of death. That's a pretty important point. That means that a general clause in the will leaving all registered retirement savings plans or all registered retirement income funds to a named person is effective for only those plans that existed at the time that the will was executed. If additional plans are subsequently acquired, then the purchaser wishes to have that person originally named in the will as a beneficiary, he has to do something. He has to name that same person as a beneficiary with the institution on their designation form, or he's got to execute a new will. or prepare a codicil to have a current date after the new retirement savings plan or after the retirement income fund is purchased, or make no designation when the new plans are purchased and assume that if there's no inconsistent designation, that the designation in the will may apply. May apply. Not will, but it may apply. The most prudent course of action, of course, would be to follow the options, to name that same person as a beneficiary with the institution on the designation form, or to re-execute a new will or prepare a codicil with a current date that includes that will. So that's an oversight people don't think about. Said, oh my God, that's right. No, when you say all my rich retirement savings plans, all my rich retirement income funds, it only applies to the ones that existed at the time that the will took effect. And the will is when it was signed, and of course, not when a person died. If we consider the Ashton case versus South Muskoka Memorial Hospital Foundation, here's a situation in 2008 that showed the implications of drafting a revocation clause in a will. In this case, the annuitant of a retro retirement income fund contract was made in favor of his 8 children on the application. A few years later, the father executed a new will. It altered the distribution provided for in the original application, and it also made provision for a charitable donation. So the will had the standard clause saying, I hereby revoke all wills and testamentary dispositions of every nature or kind whatsoever made by me. Very, very general clause. Mr. Ashton passed away 6 years later, and the trustees of the deceased estate asked the court to determine what were the rights of the children in relation to the funds in the Rich Retirement Income Fund, because there was no reference to the actual designation in the will. And here again, the judge picked up his crystal ball, as I will say. He considered a provision under the Succession Law Reform Act. He indicated that a revocation is only effective if it relates expressly to the designation, either generally or specifically. But the judge concluded that the general revocation clause used in most wills relates to all testamentary disposition, which includes a beneficiary designation. Again, this emphasizes how wary clients, their legal advisors, and you as financial advisors should be of using standard revocation clauses or relying on the standard revocation clauses. This case decision creates a level of uncertainty for an executor appointed under a will if the testator also has made designations by instrument and the will and designations have an inconsistent scheme of distribution. So be aware of all the designations made everywhere and make sure that they are consistent. In a situation of Deschanel versus Hamill, following the death of their father, the children of Robert Hamill received from Manulife Investments their part of the Rich Retirement Savings Plan, since Manulife was considered them to be the beneficiaries of the plan. Ms. Desjardins, the spouse of Mr. Robert Hamill, asked the court to be declared the legatee of the entire Rich Retirement Savings Plan according to the dispositions of his will. And Section 64 of the Supplemental Pensions Plans Act said that the designation of beneficiaries and the revocation thereof are governed by Articles 2445 to 2459 of the Civil Code. This is a Quebec case with the necessary modifications. But what does all that mean? Well, that section of the article notes that a designation or revocation contained in the will that is null by reason of a defect of form is not null for that sole reason. Such a designation or revocation is null if the will is revoked. So a designation or revocation made in a will does not avail against another designation or revocation subsequent to the signing of the will. And it doesn't avail against a designation prior to the signing of the will unless the will refers to the insurance policy in question or unless the intention of the testator in that respect is manifest. What does that all mean? Well, all the rights, titles, and interests that he may have had in an RSP, that was what was mentioned in the will. That was mentioned. All the rights, titles, and interests he may have in an RSP. He didn't describe where that was, the policy number, nothing, the amount. That's all he said. But that's what it said in Article 4. And Hamill died in 2006. So they paid up the plan according to the designation they had in file, and she argued the point according to what the Civil Code actually said with those modifications. But the court reminded the position of some authors who have written that when faced with clear contact, the judge's role is to apply versus interpret. The will was notarized, so it makes proof against all persons of those declarations which directly relate to the will. That was fine. Robert Hamill revoked his children as beneficiaries of the RRSP when he signed his will, since he clearly referred to it in his will. So the court ordered the children to give the amounts received to Miss Deschanel with interest. With interest. So although they've been named and they thought they were going to get the money ended up going to her. So what if the spouse is named as beneficiary of the accessory annuitant? Again, what we got to think about is that for retirement income funds, when naming your spouse as a beneficiary, you're given the option of having your spouse receive the retirement income fund as a lump sum, as ongoing payments, or choosing your spouse as the accessory annuitant of the RIF. Well, how is it you want to actually set this thing up? We talk about a beneficiary. She may not be a beneficiary. She could be a successor annuitant instead. If the successor annuitant election is not made, then the deceased retirement income fund will be collapsed. And that causes a disposition of the investments in the plan, followed by a roller of the value of that plan to the surviving spouse. Now, there may be several disadvantages to this. It may not be a good time to sell the investments in the plan. There may be selling costs to consider. There's the issue of preparing all the paperwork at a difficult and stressful time for the surviving spouse. If the successor annuitant designation is made, it's effortless. The spouse simply takes over from the deceased. She continues to receive the payments in his or her place. The investments in the plan are not affected by this. There's no need to execute a new contract. So how do you affect that? Well, two ways. A spouse or common law partner is named as successor annuitant, and if the RIF plan holder has named their partner as a successor annuitant, either in the retirement income fund contract or in their will, the surviving partner becomes the new annuitant, and the payments will continue to be made to them. All amounts paid after the date of death will be taxed to the surviving partner. Now, there's a joint election by the estate and the surviving partner to treat the surviving partner as a successor annuitant, even if the plan holder has not named the partner as successor annuitant. They may do that. And the executor may allocate the retirement income fund to the surviving partner in satisfaction of an entitlement under the will by giving written instructions to the finance institution to treat the surviving partner as a successor annuitant. But you know what? Not everyone remembers how to do this. Not everyone does do it that way, so that may not be the way it ends up happening. So again, let's look at the spouse. And that could be a common law spouse as successor annuitant. And I've gone through the two advantages about what they can actually do. So even if the retirement income fund plan holder has not been named, spouse has not been a successor annuitant, there is sometimes an ability for the executor to allocate that to a surviving spouse in satisfaction of an entitlement under the will, provided there was an entitlement under the will to that money. Again, in Quebec, any amount payable to a minor beneficiary during his or her minority would be paid to the parent or guardian on his or her behalf. Anybody can be named a beneficiary of a tax-free savings account, and what you got to think about is that even though on death all funds are transferred to the beneficiary, if it's a spouse or common law partner, they may make an exempt contribution to their own tax-free savings account, not exceeding the market value of the tax-free savings account on the date of the original owner's death. The spouse preserves the tax-free status of the funds without affecting their existing contribution room, but they got to notify the Canada Revenue Agency if they're making an exempt contribution as a survivor within 30 days of the transfer. For anybody else other than the spouse, the funds are simply deregistered as of the date of death of the original owner. They're no longer tax sheltered. Funds are transferred on the non-registered account in the beneficiary's name, and any future capital gains, interest earnings, dividends are calculated using the value of the investments as of the date of death of the original owner. So growth afterwards is taxed to beneficiaries. As a successor holder, instead of being named as beneficiary, that of course is restricted to a designated spouse or common law partner. On death, the ownership is transferred to the spouse, and the survivor keeps the tax-free status of the funds without affecting their existing contribution room. Relative advantages: no probate fees to the beneficiary, income tax on the growth between the death and transfer dates. Think about that. Money can move to the spouse's tax-free savings account if they're named as a beneficiary on the election. As a successor holder, Also, no probate fees. There's no tax issues though, since the money never was deregistered. You don't have to worry about what happens between the time of death and the time of the actual transfer. Money will remain in the tax-free savings account. Designations, though, are very account specific. So you can name different successor holders or beneficiaries to each account. And people may have more than one tax-free savings account. It's up to you then, as a client, it's up to you as an advisor to ensure that the correct estate information is assigned, of course, to each account. And I have articles on that that you can access on the Empire website that goes into that in a lot more detail. Planning point again, whether you're naming a beneficiary or a successor holder, if you're looking at the latter part, name a beneficiary as well. Because if you and the successor holder die at the same time, the beneficiary will get the tax-free savings account. And also remember that during the lifetime of the successor holder and the beneficiary, the successor holder overrides the beneficiary designation if they're both alive. And in Quebec, typically a tax-free savings account can only be passed through the estate. So let's look at these conversions. I've talked about rich retirement savings plan to rich retirement income fund conversions earlier, and the fact that there's no automatic beneficiary carryover. And I do get a lot of questions on this issue. Again, individual institutions may handle internal conversions differently, and a carryover may apply. Empire Life is one of those companies. At Empire, both the investments and the beneficiary designations in a rich retirement savings plan carry over to a rich retirement income fund as a default for segregated funds. And that's confirmed in the information folder that the client receives when the plan was actually set up. So I'm not just saying that. I read a couple articles on that. It's actually confirmed in the information folder. One issue, of course, is that the original beneficiary designation set up on the plan may have been completed decades ago. There may have been a divorce or two. Children of the past are estranged. So does it reflect the current wishes of the owner? And if a spouse or common law partner is named beneficiary of the rich retirement savings plan and then is named successor annuitant under the RIF, who's the beneficiary of the plan? There may no longer be a beneficiary of the plan. That's why it's so important to name somebody. So as I said, I often get questions, and I wrote an article about this sitting on the Empire Life website on our case in point about how to structure your financial affairs to meet their income expectations in retirement. In one example, I talked about Sam and Christine, who live in Moncton, New Brunswick. Sam is celebrating his 71st birthday. He held on to his rich retirement savings plan for as long as possible to optimize the tax sheltering benefits of that plan, and named his wife Christine as the beneficiary. Now, Sam wants to convert his rich retirement savings plan to a rich retirement income fund. He wants to ensure that Christine gets comfortable with the investment mix, and he wants to make sure that she'll continue with it. And they think that all they have to do is complete a form converting his rich retirement savings plan to a rich retirement income fund with the same financial institution, and just figure out how much they need each month to help fund their lifestyle. And Christine will automatically receive the payment stream when Sam dies, right? Well, let's break that down. As I've said a number of times, and I keep repeating it because I keep getting questions, Christine does not automatically continue to be the beneficiary of the rich retirement income fund. Aside from Empire Life, and maybe a few other companies, and British Columbia now has passed some legislation to help out with that as well. But in most provinces and most places in the country, that isn't the rule. A carryover isn't the rule. If Sam doesn't name Christine as the beneficiary of his rich retirement income fund, then when he dies, the balance may be commuted and paid to his estate. So Sam has to make those specific designations either with the financial institution or in his will. And when he does that, then the plan is commuted, she gets the value. The underlying investments are sold, the balance is paid to her. If she wants to have a rich retirement income fund, she sets a new one, and the plan terms and conditions are recalculated on her age. And the plan's in force at that point in time. The plans that are available that she can buy. If the estate is the beneficiary and there is a valid will naming the spouse or common law partner as the residual beneficiary under the will, then the executor or estate administrator and the spouse partner may be able to make a joint election to roll over part or all of the plan at death into the survivor's register plan. It's very important that you say all or part. And you said, well, why wouldn't you roll over the whole thing? Why would you always make them successor annuitant? Why would you roll over not roll over the whole thing? I said, from a tax planning perspective. If you have a client who, and it's Sam and Christine, and Sam dies in March of this year, and he didn't have a lot of income to declare for the first 3 months, and Christine does, she may be working, she has other income, she'd be better off leaving, rejecting, not having all that money roll over. Have some of that money taxed in Sam's estate at a much lower tax level. She collects the money after tax and has more money to spend. Whereas if it's all rolled to her and she's in a higher tax bracket or she needs the money, it bumps her into a higher tax bracket, she'll have less money to spend. So from a tax planning perspective, it doesn't always make sense to roll over everything. Look at the time of year, look at the earned income to date, the taxable income to date of an individual when they pass away, and then make a determination as to whether or not you want to do a full or partial rollover. Again, if Sam had intended to preserve both the investment structure and the payment stream of his registered retirement income fund to Christine, he should have named her as a successor annuitant, either in the plan document or in a will. And that way, she simply takes over the plan. Again, there's the article I wrote on that particular situation. I wrote another one on registered retirement income funds and changing beneficiaries to annuitants, a slightly different fact pattern. Feel free to go to the website and grab this and other related articles when you're talking to your clients or to get a better understanding of how this thing works. Again, the impact that if you name someone as a beneficiary on the death of the annuitant, the owner, the plan is collapsed, it's commuted, the assets are transferred on the rollover basis of the spouse's plan. Minimum payments are based on the age of the surviving spouse, the new owner, and the fair market value of the assets on the date of transfer. That becomes a new adjusted cost base. However, if that person is named as successor annuitant, the spouse is successor annuitant, the plan is not collapsed, it continues in the survivor's name, the minimum payment schedule continues on the same basis as the original plan, and the asset book value is unchanged. And that can make a difference depending on what the underlying guarantees or so of these plans actually are. Let's look at Bulos versus Duca. Again, a case settled this year, 2020. Mr. Yura Kagek held a number of accounts at Duca Financial Services Credit Union, jointly owned with Edward Bulos. These people were good friends, good buddies. He also, Kagek had 3 RRSPs in the 1980s, designated Bulos as the beneficiary. He really didn't have a lot of family. They maintained that close friendship for decades. Bulos handled Kagek's affairs. When the latter was out of the country, Kagek's mother and only relative died in 2008, and so Kagek told Bulos of the plan to leave his entire estate to Bulos. That was the plan. Kagek turned age 71 in 2011. Duca Financial automatically converted $125,000 in his rich retirement savings plans to rich retirement income funds with new account numbers. Kagek did not sign new beneficiary forms, but he reiterated the intent for Bulos to be named the beneficiary in 2012. He died intestate in California in May of 2015. And he appeared at that point in time to have a living cousin, Agjan Jakob. And Bulos died in February 2017 before all this got settled. So Mrs. Bulos was named executor of his estate and the sole beneficiary of his estate. And she said, wow, let me trace back here. Isn't there some money that I should be getting? So again, keep in mind, when the conversion was done from the rich retirement savings plan to the rich retirement income fund, Duca Financial did not have him sign new forms. He did an automatic conversion, and because he couldn't hold on to the money in the rich retirement savings plan any longer. Duca Financial attempted to settle Kagek's account with his cousin, Mr. Jakob. They requested information, including the identity, which was not submitted. Mrs. Bulos began an application seeking Mr. Bulos as the beneficiary of Kagek's rich retirement income funds in October of 2019. Duca Financial agreed to remit the funds per a court directive. They did, however, still pursue information from Jakob, who stalled for time. He did not file an information or notice of appearance. And the court eventually declined any further requests for adjournment, and they heard Mrs. Bulos' application in writing due to COVID. So this happened during the COVID situation. And here's what they looked at. They considered the Succession Law Reform Act, which governed the beneficiary designation of interest in funds, including rich retirement savings plans and rich retirement income funds. They applied the Ashton Estate versus the South Muskoka Memorial Hospital that I talked about earlier, where rich retirement savings plans were connected to or derivatives of rich retirement savings plans from which they were converted. So that all followed through. They applied McConaughey, Wood versus McConaughey. I talked about that earlier as well, and considered unchallenged evidence of Kagic's intention to gift the Boulos his entire estate, including the rich retirement savings plans. And the RIF funds did pass the estate of Edward Boulos. So, by extension, Mrs. Boulos got all the money. Very, very important if we look at all these particular sections of the Income Tax Act to actually make sure that that work. And again, if you'd like a handout of this presentation, please reach out to your account executive and we'll send you a handout version of these slides. Now, again, we talked about these equal estate assets and unequal consequences and what in fact can actually happen here. The situation being a parent's estate where they decide to divide the estate more or less equally. A registered retirement savings plan or registered income fund goes to one child, and the open money, the non-registered assets, all the other assets goes to another child. In fact, there may even be some more money in there to take care of funeral costs and what have you. So let's say that you've left in this situation $250,000 sitting in that registered plan to your adult son, and you've left maybe $270,000 in a non-registered mutual fund portfolio with a pretty high component of non-realized capital gains to your adult daughter. And your assumption is that on a pre-tax amount, these portions, although not equal, well, with a little bit of taxes paid, it'll be equal after the fact. Now, what we know here is that if an individual is named the beneficiary, the registered retirement savings plan or registered retirement income fund is not subject to probate, but if the estate is beneficiary, it is subject to probate. But that's not really the big issue here. The big issue here is who assumes the income tax liability. He will get the entire $250,000 of the registered retirement savings plan, and the estate picks up the tax bill. And that's in accordance with the Income Tax Act. The income tax owing are paid by the estate before the daughter receives what's left over. Well, that works out to about half the value of the registered retirement savings plan. Plus, there's the tax on the triggered capital gains of the mutual fund. What could the daughter get? Well, she may end up getting less than $100,000 or less. How awkward is that going to be on the family get-together, even if it ever happens? And this was supposed to be a fairly equal division of the estate. Now, where there aren't enough assets in the estate to pay the tax on the registered retirement savings plan or registered retirement income fund, the Income Tax Act reduces that inequity by considering the registered retirement savings plan to be beneficiary to be jointly liable for the tax for amounts owing. And that's covered off in section 160, paragraph 162(1) of the Income Tax Act in Canada, that when a deceased RRSP's annuitant's estate does not have enough assets to fund the tax liability created by the registered retirement savings plan at death, that the registered retirement savings plan beneficiaries are jointly and severally liable for that excess liability in proportion to the amount attributed to the benefits received. Now, this is where things work a little bit differently. With a registered retirement savings plan, they could be liable for all of it. So if there were two beneficiaries on that screen, if you looked at the son, there were two people there, they could go after either one for all of it. With the registered retirement income fund, they could go after each of the beneficiaries of the RRSP, if there are two of them on that screen on the left-hand side, for the proportion amount they actually receive. So different treatment really in terms of what actually happens, depending on whether there is one or whether there are more. In the case of O'Callaghan, a case settled in 2016, Tax Court of Canada 169, a sister was the beneficiary of her brother's registered retirement savings plan. She was held liable for the brother's terminal year tax, even without the estate being assessed. So the Canada Revenue Agency can get pretty aggressive when that actually happens. So what are some planning points? Get your beneficiary designations up to date. Make sure that what's in your will match everything else. If the estate is named as the beneficiary, again, the entire registered retirement savings plan is taxable to the estate in the year of death. If the spouse or common law partner can elect jointly with the executive of the estate to transfer all or part of that RSP to him or her, then that gets deferred. So make sure they're up to date. Make sure they reflect the current wishes of the owner. Are they in sync with the will and other documents? Do there need to be special provisions and tactics for spouses? And does everybody understand what the tax implications are and who could actually be held liable? So again, what are some viable alternatives? Name all children as beneficiaries to share the tax debt if owing. Allocate a portion of the registered retirement assets to the estate to cover the taxes. Have a will provision that whoever is the beneficiary of the registered retirement savings plan, without even naming the amount, is responsible for the income tax and responsible for paying that income tax directly to the Canada Revenue Agency. So document and communicate unequal distributions and explain the income tax consequences. I go back to the Callahan case, um, and this was pretty grievous here. Is the person who actually got the Registered Retirement Savings Plan didn't reimburse the estate, but actually paid the money to the executor. The executor kept the money, and the Canada Revenue Agency went after her for the second amount owing. So again, if you're going to have to pay the tax anyway, do not pay it to the executor, to the trustee, pay it direct to the Canada Revenue Agency. You've got your receipt, you've got the money, and everything should be kosher. If we're looking at tax beneficiaries and the Canada Revenue Agency, again, I've frequently spoken about the limitations and misunderstandings which frequently occur here. If we look at Higgins versus the Queen, though, we have some interesting things that can actually happen. And I wrote about this in another article that you can get on the website as well. In this particular situation, Higgins versus the Queen in 2013, Arthur Higgins named his two adult daughters, Karen and Sandra, as equal and revocable beneficiaries of a non-registered segregated fund investment in 1999. He made a series of monthly withdrawals from that investment before he passed away in 2002. The balance was passed on to his daughters, and it wasn't a large amount of money, a little over $10,000. Arthur died without a will. His estate was quite simple. It didn't hold any assets other than a bank account, and the bank funds were used to cover funeral expenses, and so there was no really administration of the estate. The daughters didn't even know about the Registered Retirement Income Fund. What they did hear is that there was some type of an insurance policy, and they found, in fact, that there was a Registered Retirement Income Fund and a non-registered investment that was held through an insurance company, and all the monies were paid to the daughters because that was the beneficiary designation on file. Now, what happened is that the advisor told the daughter that no income tax would be owing since they were life insurance policies. So that was the advice given by the financial advisor. But the daughter held some money just in case. And Karen followed up and discovered that maybe there is some money be owing. And so she had a series of discussions with the Canada Revenue Agency about income taxes, and the Canada Revenue Agency said, no income tax is payable on the proceeds from a life insurance policy, which is the way that she positioned it. The Canada Revenue Agency did ask Karen to file a tax return on behalf of her father. She sent in some documentation. She did not prepare and file a tax return. Discussions continued from 2004 to 2007, during which time Karen was advised that the Canada Revenue Agency would not pursue the collection of income taxes because there was such a small amount owing. And things went really quiet until 2010. Well, in 2010, a Canada Revenue Agency agent informed Karen that Arthur Higgins' account was in arrears of taxes owing. And the amount owing under the assessment on the non-registered account alone was almost $5,100. And this sold the Registered Retirement Income Fund to be concerned about. So the daughters appealed the assessment, and the matter eventually went to the Tax Court of Canada. The Canada Revenue Agency took the position that a transfer of a non-registered insurance segregated fund had occurred from Arthur's estate, and therefore tax was owed. Additionally, the Canada Revenue Agency felt that the non-registered investment did not fall under the category of life insurance. Arthur's daughters argued that they, not Arthur's estate, were the beneficiaries of the segregated fund investment under the contractual terms of the contract, and the proceeds passed directly to them, which they did. The investment was issued by an insurance company, and in their opinion, was similar to a life insurance contract. So Justice Rowe concluded that the segregated fund was both a regular investment and a life insurance policy, and the right to name a beneficiary who would receive the balance of any remaining funds on the death of the owner was an integral feature of the segregated fund. So as such, the funds that the daughters received as beneficiaries were considered life insurance proceeds and did not form part of Arthur's estate. The court found that the segregated fund contract was protected under the preferred class provisions of the British Columbia Insurance Act. The Canada Revenue Agency could not hold the daughters jointly and severally liable for their father's income tax liability on that non-registered asset, but they were held jointly and severally liable for the correct amount of tax on their dad's Registered Retirement Income Fund, proportionate to what each received as beneficiaries, and that was settled and according to under paragraph 162 under the Income Tax Act of Canada. So that's how that went. Very, very interesting development and judgment. Again, I wrote an article about that, which quotes all those sections of the Income Tax Act that you can refer to at your leisure. So tax courts may be inconsistent. They may be inconsistent in terms of their rulings, especially for married couples. Again, when you look at cases like Kipperchuk versus the Queen and Kushta versus R in 2015, life insurance death proceeds paid to beneficiaries generally not part of the estate assets, but a regular investment paid outside the estate on instructions of will are generally considered to be an asset transfer. So name your beneficiary with due consideration. Again, look at the conventional practice versus tax implications and other planning. Again, the conventional practice to name a beneficiary, particularly when it's a surviving spouse, because it avoids everything. But again, that conventional, almost automatic estate planning strategy probably deserves more scrutiny than it takes. For the strategy that I mentioned earlier about minimizing taxes by rejecting, not taking all the money all at once and only transferring some of the money to a surviving beneficiary. Again, generally in Quebec, it's generally not possible to name beneficiaries on rich retirement savings plans or rich retirement income fund applications. So you're dealing with banks, you're dealing with mutual funds and that sort of thing. Those assets generally flow through the estate of the deceased and are governed by the terms of the deceased will. There are some exceptions for insurance-based contracts. Again, consider the ramifications of revocations. Frequently, the plan issuer is not informed if there's made a change, maybe made in a will and not someplace else. And again, if the will is revoked, so is the beneficiary designation, and now there may be no beneficiary designation whatsoever. That case, of course, the best example, of course, is to go back and think of the Ashton case, the Ashton Estate versus South Muskoka Memorial Hospital, which demonstrates the implications of drafting revocation clauses as well and not really being clear and causing a lot of confusion. In this slide, you've had maybe a few seconds to look at it right now. This one gets fairly complicated because here we have the Claudio Gaudio estate trustee versus Deborah Ann Gaudio, who's a surviving ex-wife, the Great West Life Assurance Company, the Bank of Nova Scotia, the National Life Assurance Company, where we've got a situation here that further indicates that the courts require clear evidence of an intention to change the designation of an insurance vehicle, where documents like a separation agreement, and that's all they had here, they had a separation agreement which contains clauses which typically release parties from making any claims against each other's estate, may not affect the designation in an insurance plan. That's what happened. Even though there was a separation agreement between the deceased and his ex-wife, the designation in favor of his ex-wife was still effective with all those organizations. She got all the money, all of it. Also consider that a beneficiary designation created by declaration in the will is always revocable, even if the testator indicates that it's supposed to be irrevocable, because if a will is revoked, then the designation in the will is also revoked. All right, also think about that. Courts require clear evidence of an intention to change the designation of an insurance-based vehicle. So again, documents like a separation agreement with release clauses may not affect designations in insurance-based plans. They may not affect it in other plans either, as was the case in this one right here, the case of Francesco Gaudio. In Quebec, of course, legal separation, the partner's designation as a beneficiary will be maintained unless it's otherwise declared by a court order. Divorce terminates a beneficiary designation, but the dissolution of a common law relationship has absolutely no effect on the designation of a common law partner as a beneficiary of a policy. So test everything here. The time and the costs of going to court could have been saved had the drafter of the will consulted a financial advisor, confirming the current designation in the existing insurance contract, and made all the appropriate filings. If the lawyer knew that the designation was not the case, then it's most likely the lawyer may have added an appropriate revocation clause in the last will and testament. So why take the chance? Periodically stress test these plans, stress test the documents in place, look at all of them to make sure that everything is lined up the way it's supposed to be. And engage with qualified professionals who can work together with you to ensure that your wishes and the wishes of your clients are preserved. In closing right now, I want to spend just a few minutes talking about powers and limitations and what happens when advisors get involved and the advice you may give with beneficiary designations and even acting under a power of attorney. A misconception, if not an outright misrepresentation, of course, is that as licensed financial advisors, that you're not subject to rules and oversight. And There was a case settled in 2015 that serves as an example that that's not necessarily the case. Here, Kenneth Karasik had a power of attorney from a client. He was named as a beneficiary on the client's in-trust investment account. He also accepted a gift of over almost $310,000. He was MFDA licensed. The MFDA regulations forbid an advisor from accepting or acting upon a general power of attorney from a client in favor of the advisor, unless it is for his own spouse, parent, or child. The Mutual Fund Dealers Association, or MFDA, also said that Karasik put himself in a situation that could give rise to a conflict of interest by being a beneficiary on an account and accepting money from the client to invest. Now, Karasik was formerly associated with Investors Group, and that company expressly forbids its advisors from being named as a beneficiary of a client's estate or account in its policies and procedures manual. And they get advisors to answer an annual questionnaire to help determine compliance with their rules. The client in this case had made the gift some years earlier. He signed a deed witnessed by his own lawyer in recognition of Karasik's work, transitioning the client to a retirement home. Karasik denied that he was named a beneficiary in any accounts. He didn't disclose that he received the payout. He did voluntarily return the money while the client was still alive. But then the lawyer said, look, that's going to cause too many problems. Let's reverse that deposit because of the adverse legal and tax implications. So, and that was Karasik's lawyer. That was not Karasik's lawyer. That was Karasik acting on the lawyer's request, the lawyer for the client. The lawyer had been involved throughout Karasik's work with the client, presumably protecting the client's interest, which wasn't Karasik. Karasik once again returned the funds after the client died. He deposited the proceeds into an in-trust account at Investors Group so that it could be paid out to the deceased client's estranged adult children. And then he informed Investors Group in writing what happened, claiming he was never comfortable receiving the money. The upshot, what happened? The Mutual Fund Dealers Association ordered Karasik to pay a $10,000 fine, $2,500 in costs for these contraventions for not disclosing the matters on an annual questionnaire from Investors Group. They prohibited him from conducting security business in any capacity for a year, even though Karasik was already 72 years old, and with an arrangement with the Investors Group, he retired from the business. You've got a duty to properly advise here. And what is expected of a financial advisor in terms of advice on naming beneficiaries? Can there in fact be liabilities for not advising properly? Generally speaking, financial advisors do have a duty to advise their clients, and a failure to do so may trigger a liability for losses experienced by clients through errors. How does that liability arise? One, well, there's a duty to advise if the client holds himself out as being able to provide advice. And two, that duty hasn't been carried out. So you've got a duty to advise, you didn't tell them, or you just don't carry out the instructions. The client isn't informed about a matter of factor that the advisor claims or advertises to be knowledgeable about. Advisors owe their clients some duties as part of their trusting relationship. And as a best practice, you should be clear and document as to the type and client advice that you actually give. And thirdly, if the client relies on the advisor to provide that kind of information to make or not make a decision, the client understands the consequences of any action, they may or may not, and that lack of advice causes the client to experience a loss, they can go back on the advisor. So let's consider this particular case here. BC Court of Appeals case, Deschernay versus Toronto Dominion Bank. Keith Hawthorne names Colleen Deschernay as common law spouse, the beneficiary of his regular retirement savings plan at a bank. She had power of attorney for property. He became incompetent. She transferred the non-registered account to TD Evergreen. She thinks of TD Bank to TD Evergreen, same organization, same logo. So far, so good. She was approached by Mr. Westcott, an advisor, to transfer the registered retirement account to TD Evergreen. No beneficiary designation was made. Keith died. The proceeds were paid to the estate, and Colleen was not a beneficiary of the estate. She was under the impression that the beneficiary designation made under the registered retirement savings plan at TD Bank would carry over to TD Evergreen. It was essentially the same company as far as she was concerned. She wasn't very sophisticated. So what the court said is that TD Bank and TD Securities knew of the failure to designate a common law spouse as a beneficiary. They knew that they were negligent. The bank was found not liable by Court of Appeal. They had no duty to ensure the beneficiary designation on the transfer out, only that she was a valid attorney, because she did this under a power of attorney. The investment company was liable. The advisor was found to be in a fiduciary relationship. and the client was deemed to be unsophisticated with little investment knowledge, and she asked for advice and didn't get it. The court said that Westcott, the advisor, was told of her limited knowledge and understanding. He held himself out as being able to give investment advice, someone that clients could be relying on for investment advice. He placed markers on the application for the signature, except for a beneficiary designation. And he admitted he owed the plaintiff a duty to advise clients to act fully, carefully, honestly, and good faith. He really wasn't a very good witness, and you could argue just how good an advisor he actually was. He failed to explain that bank and investment companies were separate entities. He failed to explain the importance and consequences of setting or continuing a beneficiary designation or not doing it. So he breached his duty to advise. And so she was awarded full recovery of the registered retirement savings plan plus interest and costs. An expensive lesson for the firm, expensive lesson for the advisor. Again, for property dealings that can impact testamentary dispositions, when you're dealing with powers limitations of a person acting under a power of attorney or a protection mandate, does the item or topic change after death? If so, we can't make the change because it could be deemed to be a testamentary disposition. Does the change require evidence of insurability? A power of attorney can't act for somebody else who's incompetent. And again, if you're looking at any type of electronic fund transfers, they got to be payable to the policy owner's bank account, regardless of the banking institution. The particular thing I'm going to focus on today as I close off the session is the ability to change your designated beneficiary, which is only available in very limited situations. Again, in most situations, a person acting on a power of attorney cannot make or change a beneficiary designation. I referred earlier in my session to the fact that it may be permitted in BC. Some companies will allow it to maintain a beneficiary designation made by the policy owner. We may allow that. Other companies may allow that as well. If that designation had made while that policy owner was capable at the time for a registered product at one financial institution, and the funds are transferred to another, or they're transferred from a registered retirement savings plan to a registered retirement income fund. BC legislation also authorizes the attorney to change a beneficiary designation if authorized by the court, but no other situations. Again, we updated this chart just a few months ago. So this gives you all the different things that the person acting on a power of attorney or protection mandate can and cannot do. Again, 1 out of 4 Canadians is going to be 65 and over by 2036. There is no common investment standard or approach universally applicable to elders or for anybody for that matter. We know that people as they get older are not a homogeneous group. Some generalities do apply. A lot of the things you may think focus on the retired or near retired. Certainly a lot of the claims didn't involve people that were older, even though the beneficiaries may not have been older. So few issues are unique to elders, but the impact is certainly greater when these people get involved. So you're dealing with market diversity. There's the impact of lost capital, the suitability of investments. Think of all the non-investment tax considerations that people are simply not aware of or need to be reminded of. And you've got to look at balancing the needs of the elder, the family, the legacy, and making sure that everything falls into place and people really have a complete picture of what may happen depending on how they set certain things up. They may have cognitive issues with physical decline. There may be multiple decision makers. There may be multiple claimants at the end of the line if people don't get what they want or what they expect. So we reviewed the perils and pitfalls of naming beneficiaries and probate avoidance, estate equalization issues, unintended consequences. I've gone through a lot of case study examples and certainly left you with what I hope are some very, very effective planning points. Finally, as I said during a lot of my presentations, plan ahead. Ask lots of questions. Do not make assumptions. Review things on an ongoing basis. Stress test them. Go through a financial fire drill. And wherever and whenever possible, get professional help. Thanks for listening in.